If you've ever felt a little paranoid about sharing your $1 million idea with the government, you're not alone. But lately, that paranoia has been backed up by some pretty shocking headlines. Just last month, the Department of Justice announced a $500,000 settlement with a patent examiner named Daxin Wu. According to reports from IP Watchdog and the DOJ, Wu allegedly reviewed at least 9 patent applications from companies where she held 6-figure stock positions. In one case, she owned over $900,000 in a company's competitor while reviewing their filings. Now, this follows an Inspector General report estimating that nearly 30% of patent examiners had potential financial conflicts that were going undetected. For years, the rule was that an examiner could own up to $15,000 in a company's stock and still review their patents. But as of March 2nd, 2026, that has officially changed for the better. USPTO Director John Squires just issued a major memorandum that completely eliminates that $15,000 buffer. If a patent examiner or even their spouse owns a single share of stock in a company, they are now strictly prohibited from touching that company's patent applications. This is a big shift toward transparency. The USPTO is finally admitting that even a small financial stake can create a conflict of interest that undermines the entire system. I see this impact of this paranoia all the time with my clients. Inventors are naturally protective of their ideas. They've heard the stories of big corporations taking ideas and making millions without paying a dime. I recently sat down with a client who was terrified to file a patent application because his biggest competitor was a massive tech giant. He asked me, how do I know the person deciding my fate isn't a shareholder for the other guys? I told him then, and I'll tell you now, while the vast majority of examiners are honest professionals, this zero-tolerance policy is the safety net we've been waiting for. It's a clear signal from the top that the USPTO has your back. You have to trust the process, but it definitely helps a lot when the director of the USPTO proves he's prioritizing fairness. This update is a huge win for the little guy. It builds the confidence you need to move forward without looking over your shoulder. When you and I work together to file your patent application, we're entering a field that is more level than it has ever been before. I'm Mark Trenner, and I work directly with inventors to navigate these changes. If you've been sitting on an invention because you're worried about the fairness of the process, now is the time to act. Click the link in the description to book a consultation with me, and let's get your invention the protection it deserves.